Good morning to all. Today we will discuss about the sexual harassment of women at workplace. As enshrined in the preamble to the Constitution of India, equality of status and opportunity must be secured for all its citizens. Equality of every person under the law is granted by Article 14 of the Constitution. A safe workplace is therefore a woman's legal right. Indeed, the constitutional doctrine of equality and personal liberty is contained in Article 14, 15 and 21 of the Indian Constitution. These articles ensure a personal right. These articles ensure a person's right to equal protection under the law, to live a life free from discrimination on any ground, and to protection of life and personal liberty. Sexual harassment constitutes a gross violation of women's right to equality and dignity. It has its roots in a patriarchy and its attendant perception that men are superior to women and that some form of violence against women are acceptable. One of these is workplace sexual harassment, which views various forms of such harassment as harmless and trivial. Often it is excused as natural male behavior or harmless flirtation, which women enjoy. Contrary to these perceptions, it causes serious harm and is also a strong manifestation of sex discrimination at the workplace. Not only is it an infringement of the fundamental rights of a woman under Article 19(1)(g) of the Constitution of India to practice any profession or to carry out any occupation, trade or business. It erodes equality and puts the dignity and the physical and psychological well-being of workers at risk. This leads to poor productivity and a negative impact on lives and livelihoods. To further compound the matter, deep-rooted socio-cultural behavioral patterns which create a gender hierarchy tends to place responsibility on the victim, thereby increasing inequality in the workplace and in the society at large. In 1992, a rural-level change agent, Bamri Devi, was engaged by the state of Rajasthan as a Sathan to work towards the prevention of the practice of child marriages. During the course of her work, she prevented the marriage of a 1-year-old girl in the community. Her work was met with resentment and attracted harassment from the men of that community. Bamri Devi reported this to the local authority, but no action was taken. That omission came at great cost. Bamri was subsequently gang raped by those very men. The Bamri Devi case revealed the ever-present sexual harm to which millions of working women are exposed across the country, everywhere and every day, irrespective of their location. It is also shows that extent to which that harm can escalate. The Bamri Devi case revealed that ever-present sexual harm to which millions of working women are exposed across the country, everywhere and every day, irrespective of their location, It also shows that extent to which that harm can escalate if nothing is done to check sexually offensive behavior in the workplace. Based on the facts of the Bamri Devi case, a public interest litigation was filed by Vishakha and other women groups against the state of Rajasthan and Union of India before the Supreme Court of India. It proposed that sexual harassment be recognized as a violation of women's fundamental right to equality and that all workplaces, establishments, institutions be made accountable and responsible to uphold these rights. In a landmark judgment, Vishakha vs. State of Rajasthan 1997, the Supreme Court of India created legally binding guidelines basing it on the right to equality and dignity accorded under the Indian Constitution as well as by the UN Conventions on Elimination of All Forms of Discrimination against Women. It included a definition of sexual harassment, shifting accountability from individuals to institutions, prioritizing prevention, provision of an innovative redress mechanism. It places responsibility on employers to ensure that women did not face a hostile environment and prohibited intimidation or victimization of those cooperating with an inquiry, including the affected complainants as well as witnesses. Three key obligations were imposed on institutions to meet that standards, namely prohibition, prevention, redress. In 2013, the Government of India notified the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act. What is a workplace? A workplace is defined as any place visited by the employee arising out of or during the course of employment, including transportation provided by the employer for undertaking such a journey. As per this definition, a workplace covers both the organized and unorganized sectors. What is sexual harassment? Sexual harassment includes any one or more of the following unwelcome act or behavior, whether directly or by implication, namely: number 1, physical contact or advances; number 2, a demand or request for sexual favors; number 3, making sexually colored remarks; number 4, showing pornography; number 5, any other unwelcome physical, verbal or non-verbal conduct of sexual nature. So, what is the difference between unwelcome and welcome? Unwelcome meaning when you feel bad, one-sided, powerless, power-based, unwanted, illegal, invading, demeaning, causes anger and sadness, causes negative self-esteem. When it is welcome, you will feel good, reciprocal, in control, equality, wanted, legal, open, appreciative, happy, positive self-esteem. What is the impact of sexual harassment? It can be professional or personal. Now we will discuss about professional impact. Decreased work performance, increased abstinence, loss of pay, loss of promotional opportunities, retaliation from the respondent or colleague or friends of the respondent, subjected to gossip and scrutiny at work, being objectified, becoming publicly sexualized, defamation, being ostracized, having to relocate, Job and career consequences. Weakened support network. What are the personal effects? These are depression, anxiety, panic attack, traumatic stress, sleeplessness, shame, guilt, self blame, difficulty in concentrating, headache, fatigue, loss of motivation, personal difficulties with time, eating disorders, feeling betrayed or violated, feeling angry or violent towards the respondent, feeling powerless, loss of confidence and self esteem, overall loss of trust in people, problem with intimacy, withdrawal, and isolation. Some examples of behavior that constitute sexual harassment at workplace. Number one, making sexually suggestive remarks or innuendos. Number two, serious or repeated offensive remarks such as teasing related to a person's body or appearance. Number three, offensive comments and jokes. Number four, inappropriate questions, suggestions, or remarks about a person's sex life. Number five, displaying sexist or other offensive pictures, posters, MMS, SMS, WhatsApp, or emails. Number six, intimidation, threats, blackmails around sexual favors. Number seven, threats, intimidation, or retaliation against an employee who speaks up about unwelcome behavior with sexual overtones. Number 8. Unwelcome social invitation with sexual overtones, commonly understood as flirting. 9. Unwelcome sexual advances which may or may not be accompanied by promises or threats, explicit or implicit. 10. Physical contact such as touching or pinching. 11. Caressing, kissing, or fondling someone against her will. 12. Invasion of personal space. 13. Persistently asking someone out despite being turned down. 14. Stalking an individual. 15. Abuse of authority or power to threaten a person's job or undermine her performance against sexual favors. 16. Falsely accusing and undermining a person behind closed doors for sexual favors. 17. Controlling a person's reputation by rumor mongering about her private life. Some examples of behavior that may indicate underlying workplace sexual harassment and merit inquiry. Criticizing, insulting, blaming, reprimanding, or condemning an employee in public. Number 2. Exclusion from group activities or assignments without a valid reason. Number 3. Statements damaging a person's reputation or career. Number 4. Removing areas of responsibility unjustifiably. Number 5. Inappropriately giving too little or too much work. Number 6. Constantly overruling authority without just cause. 7. Unjustifiably monitoring everything that is done. 8. Blaming an individual constantly for errors without just cause. 9. Repeatedly singling out an employee by assigning her with demeaning and belittling jobs that are not part of her regular duties. 10. Insults or humiliation, repeated attempts to exclude or isolate a person. 11. Systematically interfering with normal work conditions, sabotaging places or instruments of work. 12. Humiliating a person in front of colleagues, engaging in smear campaigns. 13. Arbitrarily taking disciplinary action against an employee. 14. Controlling the person by withholding resources like time, budget, autonomy, and training necessary to succeed. Now we will discuss about the prevention and prohibition. Three persons are responsible for prevention and prohibition. Number one is the employer. Number two is the appropriate government. That may be the central government or maybe the state government, depending upon the control on organization. And third is the district officer. State governments will notify a district magistrate, additional district magistrate, collector, deputy collector as a district officer at the local level. The district officer will be responsible for carrying out the power and function under the act at the district level. So what are the responsibilities of above mentioned authorities? Number one, create and communicate a detailed policy. Number two, ensure awareness and orientation on the issue. Number three, constitute complaint committee in every workplace and district so that every working woman is provided with a mechanism for redress of her complaint. Ensure complaint committee are trained in both skill and capacity. Number 5. Prepare an annual report and report to the respective state government. Number 6. District officer will also appoint a nodal officer to receive complaints at local level. The Act provides for two kinds of the complaint mechanisms: internal complaint committee and local complaint committee. All complaints committees must have 50% representation of women. Internal complaint committee or local complaint committee members will hold their position not exceeding 3 years from the date of their nomination or appointment. Internal complaint committee. Every organization having 10 or more employees will have internal complaint committee. Every employer is obliged to constitute an internal complaint committee through a written order. The ICC will be composed of the following members: Local Complaint Committee. The district officer will constitute an LCC in every district so as to enable women in the unorganized sectors or small establishments to work in an environment free of sexual harassment. The LCC will receive complaints. Number 1. From women working in an organization having less than 10 workers. Number 2. When the complaint is against the employer himself. Number 3. From domestic workers. Composition of local complaint committee is as follows: dissemination of information and awareness generation. Employer, district officer have a legal responsibility to: Number 1. Effectively communicate a policy that prohibits unwelcome behavior that constitute workplace sexual harassment and provides a detailed framework for prevention and redress process. Number 2. Carry out awareness and orientation for all the employees. Number 3. Create forums for dialogues. For example, Panchayati Raj institutions, Gram Sabhas, women groups, urban local bodies, or like bodies as appropriate. Number 4. Ensure capacity and skill building of the complaint committee. Number 5. Widely publicize names and contact details of complaint committee members. Now we will discuss about the redress mechanisms. Who can complain and where? Every employee can complain either at internal complaint committee or local complaint committee depending upon the workplace. What should the complaint contains? Now we will discuss about the rights of the complainant. An empathetic attitude from the complaint committee so that she can state her grievance in a fearless environment. Copy of the statement along with all the evidences and a list of witnesses submitted by the respondent. Keeping her identity confidential throughout the process. Support in lodging FIR in case she chooses to lodge criminal proceedings. In case of fear of intimidation from the respondent, her statement can be recorded in absence of the respondent. Right to appeal. In case not satisfied with the recommendations or findings of the complaint committee. Right of the respondent. A patient's hearing to the present his case in a non-biased manner. Copy of the statement along with all the evidences and a list of witnesses submitted by the complainant. Keeping his identity confidential throughout the process. Right to appeal in case not satisfied with the recommendations or findings of the complaint committee. The sexual harassment complaint process. Stage 1. Receipt of the complaint. Stage 2. Planning carefully. Stage 3. Interviews. Stage 4. Reasoning. Stage 5. Finding and recommendations. Stage 6. Report. Timelines as per the Act. Submission of complaint within 3 months from the last incident. Notice to the respondent within 7 days of receiving copy of the complaint. Completion of inquiry within 90 days. Submission of report by ICC or LCC to the employer or DO within 10 days of the completion of the inquiry. Implementation of recommendations within 60 days. Appeal within 90 days of the recommendations. मुझे पूरी उम्मीद है सभी महिलाओं को मेरी इस वीडियो से बहुत बहुत हेल्प होएगी, वो जागरूक होएंगी उनके राइट्स क्या है और कहाँ कंप्लेन कर सकती है, किसके पास कंप्लेन कर सकती है। नमस्कार, जय हिंद।